Just a disclaimer, the opinions expressed in this podcast are our own views and views of our guests. Nothing in this podcast is to be taken as legal advice.
Your LexisNexis legal research and AI technology experience is now even more powerful with Lexis plus AI, now with Protégé, your personalised AI assistant that will transform your legal work. Find out more today at lexisnexis.co.nz.
Kia ora, tēnā koe, and welcome to That's Just Criminal with me, Annabel Cresswell, and my co-host,
Sumudu Thode.
Just 1 second too late there.
It really annoys her because I just did it.
So
That
it's like
1 second before I say
every
my
week,
name.
it's like a complete surprise that's how is what is required. Sumudu, who do we have in our studio today as our guest?
We've got Nick Chisnall KC this evening with us.
Now, we're going to have an introduction to Nick in a moment. Sumudu's going to go through his millions of credentials, but what is our topic for today, Sumudu?
We are going to talk about appeals, which is Nick's specialty.
Tell us a little bit about Nick Chisnall KC.
Well, see, Nick, I chat GPT'd you for an intro, which is the first time that I've actually used chat GPT for a bio. So let's see how many of these things we've got right. It tells me that you've got an LLB and a BA.
Yes, indeed.
Oh,
Okay.
God, we're going to be here all night.
Well, it's not that long.
Just get to the highlights.
You took Silk in 2022.
That's true.
That's true. You specialise in criminal law, appeal work, and employment law.
Yeah, I put the employment law thing in there so that I look like I have another string to my bow.
So did you write that whatever she's reading off ChatGPT?
Yeah.
It must be from your
influenced
website.
it.
Oh, I see. All right. Specialises in appellate, has experience on both sides.
Yep.
That's
Public
right. I'm
defence,
very even keeled.
prosecutions.
Yep. Police prosecutions, PDS, appeals at the PDS, Crown law, and as a barrister sole. And Nick Chisnall is also a friend of the pod from way back because we like to have a KC go over each episode to make sure we're not saying anything illegal. And Nick is usually the KC we go to because he's the KC that we know that knows what a podcast is, aren't you?
I had to look it up. I chat GP'd it, I should say.
The topic today, Nick, is your area of expertise, which is appeals. And sometimes we get questions from our listeners, so we have a vague idea of what people want to know about. And the question we get asked a little bit is, what kind of cases do you appeal? When do you decide what you're appealing? Is that too broad a question, or can you answer that?
Oh, look, I'll have a stab at it. The most common appeals are ones which come at the end of a case. So conviction and sentence appeals, which have to, of course, wait until a decision's been reached either by a jury or a judge sitting alone, and once a sentence has been imposed. But there are other kinds of appeals as well, and the most common that we deal with in the criminal jurisdiction are pre-trial appeals against decisions in relation to, most commonly, the admission of evidence, where a party says, look, I don't want the jury to hear that. And so those are done increasingly rarely, though, because the Court of Appeal has made it very difficult to hear those kinds of appeals pre-trial. Essentially, you have to show that the case almost entirely hinges on it.
Yeah.
In fact, I don't think I've done one of those in a very long time for that reason.
There was a period where the Court of Appeal were encouraging us to get those sorted out before trial, weren't they? But have they moved away from that in recent times?
Well, the criteria themselves for determining whether something should be heard pre-trial have changed recently, but not all that radically, been tightened up a little bit. But I think the rationale used to be, well, if the evidence is important, it's better to deal with it in a pre-trial setting so that if it isn't admissible, you don't end up having to have a retrial if it's held that the evidence shouldn't have been heard by a jury.
Yeah.
Now the feeling seems to be, and it's probably largely to do with workload. The Court of Appeal is extremely busy, but where most times those wait to a conviction appeal, and I can't help but think that it makes it more difficult to argue that something shouldn't have been heard when you've already had a trial and there are high stakes involved in ordering a retrial compared to dealing with it in a more isolated way in a pre-trial setting before you've got to trial.
Yeah. And so for the punters, what we're talking about is you're getting ready for your trial, you're on the line, you're being prosecuted, and the Crown say, oh, we want to bring up a few other burglaries that you've done in the past as well. And you say, that's not fair, that's not admissible, those have got nothing to do with this, or what lawyers would call that's an inadmissible propensity evidence. That might be the kind of thing that we'd be saying we'd try and go to the Court of Appeal beforehand to say, we don't want that evidence in the trial.
That's right. I mean, most pre-trial arguments relate to propensity evidence. And the word propensity used to be a dirty word in criminal law, but we're allowed to use it now. And of course, it just simply means that somebody's got a tendency or a proclivity for us to think in a certain way or to act in a certain way. So if you're charged with burglary, to use your example, and you've got 20 prior convictions for burglary, and then obviously the Crown's going to be pretty interested in using those to show that you've got that tendency to act in that particular way that you're charged with.
So we go to trial, I'm the defendant, I go to trial, I'm found guilty by a jury in 11 minutes. Then I come to you, my lawyer, and I go, oh, that wasn't fair, I want to appeal. Where do you go from there?
And so the first thing you'd say is it's my lawyer's fault.
Yeah.
Because just about every appeal involves attribution of
The lawyer's
responsibility.
wrong, always.
In order it goes my lawyer, the judge, the prosecutor, and then the jury. But the way we look at it, of course, is through the lens, which is the Criminal Procedure Act, which defines what a miscarriage of justice is. And so you have to show the Court of Appeal or the High Court, or whomever the appeal court is, that you've suffered a miscarriage of justice. And it's a pretty dull but important definition, which is either an error that's had an effect on the outcome, so something that has had a real effect on the outcome, which simply means that you're deprived of a more favourable outcome because of that error, or it's an unfair trial. So there's really a continuum, and more extreme examples of things that have gone wrong fall into the unfair trial category.
I just didn't like it. Can I appeal?
Usually you refine it a little bit from I don't like it to it was an error that caused a miscarriage, or whatever the ground of appeal. I mean, we're pretty good at finessing these things as lawyers. And often the client's instincts are right on it. The defendant says, I think that it was wrong, or that made a difference. You listen to them. But often the main beef with following a trial is the jury's decision to convict. And of course, that's a pretty unappealable kind of decision, because we essentially only in very rare cases allow what's called an unreasonable verdict appeal, because we put stock in juries' decision making. We don't ask them why they've reached a decision. And so unless you can show that there's not evidence supporting the elements of the offence, you're not going to get very far. And likewise, inconsistent verdicts where the jury convicts on one and acquits on another, that doesn't get you very far, because the Crown, all it has to do in reply is to show that there's some sort of rational basis for the differences or the difference.
With juries, there's a principle, isn't there, that what goes on in the four walls in the jury room is sort of untouchable.
Yeah. And there's a rule in the Evidence Act that says, of course, that it's only if it's in the interest of justice and in exceptional circumstances that you can go pierce that veil and ask jurors what happened. And I mean, it's quite surprising how rarely that will happen. Even if a juror writes and says, hey, look, the foreman had me up against the wall with a gun to my head telling me I had to find this guy guilty, that by itself would hope get you across the line.
But quite extreme.
Yeah, but I mean, there are some quite extreme examples.
That's just a little bit of pressure. That's just one of these things that goes on in the jury room.
Yeah.
Because there's a couple of examples. I think the late Peter Williams QC had an example where some jury members came out, and this was when he was a young man, so this is just one of those stories that's been, but I think it's in his book, that he could tell that some jurors were crying when they came out and looked really upset when they gave the verdict. So he demanded that they be polled. But that was done in the moment rather than on appeal. And then there's other examples where you get letters from jurors saying, I never wanted to do that. And the Court of Appeal just go, well, tough.
Yeah. And I mean, I suppose there's often lament. I remember a juror on one of my trials when I was prosecuting came out to me years later and saying that he and his fellow jurors often got together and talked about the case, and that they really regretted the fact that they'd acquitted this guy. I had no independent recollection of the case, which is embarrassing. But I think the thing is, I assured them, I said, look, you've got to remember that the decision you make is under some time pressure. and there's no point in second guessing it. I said, I think I was even wise enough to say that you'd be feeling far worse about it if it was the other way around.
Yeah, it's always better to acquit than to convict if they're in any way not sure. And I think when you're at the Crown too, you'd get a few emails and things saying, oh, we felt sorry for everyone. We felt that the family had been through enough, so we just acquitted on everything. But we know they were guilty, and there's just nothing you can do about that.
Yeah, which I suppose is the system working, because not that we're allowed to use a defence of jury nullification.
Yeah.
Often that's all you've got. And so there are cases where emotion carries the day. And I mean, I certainly remember cases as a prosecutor that I thought were overwhelming and juries acquitted. But I mean, having been a defence lawyer for some time now, I also think that it's often very difficult to put yourself in the shoes of a juror and imagine that pressure that they're under.
Tell the listeners what jury nullification is, because I think it's important everybody knows in case it comes in handy one day.
Oh, look, it's where you don't have a defence. It's often described as putting the Crown to proof, which is an important part of the process, of course, but it's also appealing to the jury's inner empathy and compassion in a way where you're not being too obvious about it.
Good answer.
Not that I've ever tried it myself, of course, because I always have a defence.
Yeah, same. We always do, definitely.
We're just lucky to have those clients, aren't we? The ones with defences. Yeah.
It's exhausting representing so many innocent people.
I was going to say, what's a recent case that you've done with inconsistent verdicts, or now that we've sort of moved on, where jurors have been interviewed, or in terms of an appeal against conviction?
Look, I haven't had one in a long time. I did an inconsistent verdict case, which I thought was a strong one. In fact, I even appealed to the Court of Appeal's sense of principle by pointing out that it's the first time I'd run this ground in a decade. It didn't get me over the line, but I convinced myself quite strongly, though, they got it wrong, and even to the point where we applied to the Supreme Court for leave to bring a second appeal on. And that was, like I say, a pretty sensible appeal, which didn't succeed. I haven't had any issues with jurors in recent times. I have had issues where a complainant is recanted, which involves a process of interview and testing as well, by usually an independent lawyer who goes and speaks to the complainant to find out what's happened. The only recent time I think there's been a question that the Court of Appeals raised about, or a jury, was in a prerogative of mercy case where Justice Koch delivered the decision. It was pretty obvious from a case from the 80s, I think, that Ron Mansfield KC did. And it troubled the Minister of Justice enough to send it back to the Court of Appeal, but the amount of work that was involved in actually getting the various jurors' views on things was pretty significant. And so the fact I remember that case shows how rare they are.
Yeah.
If that's the case, is the process just trying to find where those 12 jurors are now? And then what would you have an independent person interview each of them about their recollection?
Yeah, and it may well be the case that they can't identify who they all are and speak to them all.
So they've moved addresses or moved overseas
or died,
and all that kind of thing.
If it's so long past,
Which is, of course, an issue. It was a relatively old case, so I can't recall precisely what triggered it, but I think it was a letter written by a juror, and probably looked like one of the letters that we've received at various times ourselves, but it had some weight to it.
Their emails nowadays.
Yeah, often undertaken in an anonymous way. The keyboard warrior. It's amazing how often we hear from people telling us what we're doing wrong in our jobs.
I know, it's beautiful. You mentioned recanting, so that's an example where a complainant, for example, has insisted that something's been done to her, for an example, and then changes her mind years later and says, no, I lied about that. That would be fresh evidence, wouldn't it? Can you tell us a little bit about what constitutes fresh evidence? It's a bit of a curly one. Make it simple.
Yeah. So, well, there's a famous case called Lundy, which people
might have heard of it.
We might have heard of it, yeah.
Which went off to the Privy Council, which of course allowed the appeal and sent the case back to New Zealand for a retrial. But in doing so, they describe, or at least refine the rules that apply to evidence on appeal. And there are three screens that get used. And first is freshness, which just simply means, is it evidence that with reasonable diligence could have been obtained before the trial? Second, credibility. In other words, is it believable from a trustworthy source? And third, cogency. And cogency means that we've put alongside the evidence that the jury heard or the decision maker heard would have resulted in a more favourable verdict. And if you get to the point where three or preferably two of those things, if you can't get to all three, are met, the question is whether it's in the interests of justice to admit the evidence, which is sort of a go-to phrase which has different meanings depending on the context. But the thing is, with most evidence, it's pretty easy to say, well, look, with reasonable diligence, it could have been obtained for the trial. So freshness doesn't tend to be the thing that carries the day. Credibility and cogency do. And particularly when we're talking about scientific evidence, of course, where our understanding changes between a trial and an appeal, for example, especially in old cases.
Different testing methods and, all of that.
Sumudu, this is why I said Nick would be a really good guest, because he just knows the law off the top of his head and he'll just do all the talking for us and we can rest.
Chat GP.
We can just sort of say something every... It's Chat GPT.
GPT, sorry. I can never remember GP. I'm thinking about Grand Prix. That's all right. Showing my age.
His brain is like Chat GPT, though, with the law.
Yeah.
And Nick used to be my boss, and that was what it was like going into his office. You'd be like, hey, I don't know what to do. And he'd be like, well, here's 3 cases and cite them all. Similar to what you just heard, summarize
Did
the
you
law
check,
for you.
though, whether they're real? Because like AI, I might just have made up the citation.
All the mistakes I've ever made have been your fault.
Well, I take full responsibility for your terrible career.
Yeah. Yes, exactly. But so going back to the Lundy case, was that the small piece of brain? Was the fresh evidence in that case that they then tried to say?
It was more than that. It was actually a suite of evidence, including pathology. And so one of the issues in the first trial was about timing, of course, and pathologists timed it on the
French
basis of stomach
fries
contents.
In the stomach,
Yeah, that it had to have been within a certain window because the food was undigested. And then the pathologist on appeal said boo-hooed that, which ironically actually probably at the retrial helped the Crown because it made it a much more realistic idea that Mr. Lundy had been able to travel from Wellington to Palmerston North in the time rather than having to drive like a maniac. So it was an issue that obviously had downstream consequences for the trial. But one of the important things that the Privy Council said as well, we're not going to try and resolve the evidential dispute between experts. That's for a jury to do.
That's for a jury.
Yeah. And that's an important consideration for appeal lawyers because often you do get to experts. I mean, if you put one up as defence counsel in an appeal, the Crown will put up somebody with an opposing view.
Yeah.
If you grind to a halt, then the appeal should be allowed because if 2 experts are credible and cogent, then that really is a jury question.
Mm.
Yeah.
And the outcome could obviously be affected if the jury decide to believe one expert over the other.
Yeah, but of course that's where the tension is raised because, of course, your job as defence counsel is to put up your best case at trial, or at least your defendant's responsibility. And so you don't save things up. You run your case. You can't, on appeal, expect to be able to change your theory of the case and come up with another expert to back that up. And so, it's the place of a jury to decide a case, but within certain pretty important bounds.
And that's what's interesting, going back to those 3 points in the Lundy case of what fresh evidence is. If you'd gone to an expert, but you didn't use it in the trial, then that would be evidence that was available, but not used. And then but that's different from evidence that you might have used, but now you've got an updated report and you want that in, right?
That's right. And I mean, of course, we do see appeals where what I would describe as defendant's lament comes in, where evidence was in existence and it gets, having been found guilty, it takes on newfound importance. And it's not that it's never going to result in an appeal being allowed, because again, if it's credible and cogent, but of course you have to explain why it wasn't used, which comes back to the decision that was made and why it was made. And the other rule, which is pretty important to bear in mind, is that different lawyers have different views on the way in which to run a case. And like everything, there's not a right and a wrong answer. There might be a number of right answers or even a number of wrong ways to do it. But as long as your decision making is within bounds in terms of being reasonable, that a decision a reasonable lawyer would make, and that your client's informed instructions are obtained with that advice, then it's pretty difficult to overcome that and say, hey, look, despite all of that, I should be allowed to rely on this evidence that I had in my possession beforehand.
That brings us to criticising counsel, doesn't it? Because what you would need to do in those sort of circumstances is say, well, there was a report there that should have been done to show that this person didn't have the mental capacity to do a murder, say, but counsel didn't bring it, counsel didn't use it. And then you may have to go and criticise counsel to say they should have, and this is why, because it is credible and cogent, and this is why we should have the appeal. The problem is the Court of Appeal don't like us criticising counsel, do they?
Your LexisNexis legal research and AI technology experience is now even more powerful with Lexis plus AI, now with Protege, your personalised AI assistant that will transform your legal work. Find out more today at lexisnexis.co.nz. Now, back to the episode.
No, and I mean, in 2015, there was a case where 5 judges in the Court of Appeal established the rules around that, a case called Hall.
Tell us about the key points in Hall. Just churn them all out for us.
I'll turn them all out. Well, it's all about the vibe, but it's not really.
Yeah. Well, we'll just summarise it in one point. We don't need more than one. So it's a
no,
vibe.
but I mean, it's about the fact that, and the court starts off by giving the stats on the number of appeals where trial counsel error is alleged, and one, it's probably the largest category, or at least it was in those days, but probably the least successful ground of appeal.
Yeah, because of exactly what you just said before, that people do trials differently. You can't pick up a file that another lawyer's done and they run the trial differently and you go, that's wrong, you get a new shot because I would have done it differently. It has to have amounted to a miscarriage.
Yeah, so it's not about picking around the edges of somebody's performance and saying, oh, hey, look, I'm more experienced. I would have cross-examined better than this guy did. I mean, in some ways, the bar's set pretty low, you might think, because it takes a pretty, well, in the old days, in a case called Poynton, it used to be called radically. You had to show something radically wrong had happened, but it's not anymore. And that's because we're not so much about attribution of responsibility, but just whether there's been a miscarriage of justice. And so if you can show that your lawyer's made an error, either by not calling an expert or instructing an expert, for example, or where just the decision wasn't reasonable, then that should give the appellant a straight shot at making the argument. But it's a really formidable ground of appeal to run.
Exactly. And I think lawyers that are new to appellate work, it's a bit of a sign is that they go straight to criticising trial counsel. And when you've been doing it for a while, you realise that should be your last resort, because the Court of Appeal are usually not going to be swayed by that unless you've got something egregious or radical.
Yeah, but like you said, different people would take different views. No two lawyers are going to have the same view on everything, having looked at a file.
And it was a process that already existed before in a case called Thode. And so the Court in Hall refined it. But it made that point. It's like you've got an obligation to give the lawyer who represented the guy at trial a chance to respond. And so the first thing you have to do, of course, is get a waiver of privilege so that you're allowed to communicate with the other lawyer. And it's a really fraught process, because it doesn't matter how politely you word your letter, and I'm always really careful about it. I'm on an information gathering exercise, which I explain. It's not that I'm looking forward to impugning you or impeaching your performance. I want to be able to find out what happened. And often, in 99% of the cases, you get your answer. And then the other thing that Hall makes really clear is that as appellate lawyers, we have a responsibility to give advice about the merits of taking the ground. Is there a good faith basis for arguing something where you've got trial counsel's response? And funny thing is that the Crown tried to be ambitious in Hall and suggested that where you've got a file note, a contemporaneous file note written by trial counsel, then effectively that trumps anything that an appellant will come along and say in the Court of Appeal. But in reality, it works that way. It's difficult to get the Court of Appeal to accept that trial counsel has made something up or is not trustworthy, whereas appellants, convicted as they are, unfortunately do sit in a position where they're not trusted by the 3 Court of Appeal judges hearing their case.
Yeah. One thing we also were told by the Court of Appeal this year at the CBA conference is that to try and make any of our appeal points systemic, as in show that it's a systemic issue or a systemic problem. Is that something you tend to do?
No, I think the Court of Appeal saying that it's all well and good, but it's about resourcing, and a miscarriage of justice hinges on what has happened in this case. There are cases where I have put for the court information relating to something. I mean, for example, I did an Official Information Act request in a case recently in relation to the police investigative technique of getting complainants to covertly telephone and then record, a defendant, and police won't claim that they don't keep stats on that, which to me automatically means that they're doing it all the time.
Yeah.
and it's probably in the general instructions. So yes, I think it's helpful, but you've got to bear in mind, one, resourcing, and two, what it is that you're there to prove. You're there to satisfy the court that something's gone wrong. Issues with systemic problems, such as, for example, investigation techniques like using jailhouse snitches or Mr. Big, those are things which do require a wider spread of information. But that's why we, as part of the appeal process, often use interveners nowadays, which are interested parties, but not parties to the case itself, but those who can help the court to reach a reasoned decision. So the Criminal Bar Association, the Law Society, those organisations which bring that expertise to deal with the issue. And that's often where the court will invite submissions on a particular issue.
Yeah.
But it's hard for an individual lawyer representing an individual appellant to do that task.
Like you say, it's a resourcing thing, though, because some of these clients might be on legal aid, and it's what funding's available in terms of defense or, appellate lawyers, and how much time we can put into that, right? Because those are the things that take a lot of time.
They do. And I mean, generally when I started doing appeals, the reason I appealed is because I like the idea of being able to shape the law to make it better. And often you can force a sea change. And so being able to get that information and show the court that there is a real problem with it is a persuasive way in which to change the law. But it is also about recognising that you have a limited time window in which to put your case forward. And often these cases are pretty formidable in terms of size and effort that's required to make the argument. So I think as a lawyer, you should always have a weather eye on whether there is a problem, and ask your colleagues and look at the issues and see whether the case that you've got might be wider and larger and more significant than simply your client's issue.
The recent case in terms of that is probably the case that's going through the Court of Appeal at the moment, about police, looking at CCTV footage of you driving into a petrol station and just driving down the road and taking that footage. I've heard of cases where somebody's been charged, say, 30 charges of driving whilst disqualified or something, just
in 30 days,
based on on the fact that, you went to the petrol station and then you went to the pub, and then that's 2 charges. Or there's the gang insignia one as well. Yeah, we've seen you on CCTV 3 months ago wearing a gang patch. So, we now charge you with breach
it's
of
very Big Brother. I think we are definitely need a case for everyone to intervene on.
Well, there is that one at the moment, but the Court of Appeal said the CBA can't intervene. So
there's no interveners on it.
Well, there's one coming up this month, isn't it? In fact, it's being heard this week about the judge's directions on counterintuitive memory.
Oh.
Yeah.
Oh.
Well, actually, I have to say, it's surprising. We went through an enlightened phase under previous presidents of the Court of Appeal where interveners were seen as really valuable. And President Cooper and President Koch, as they were very receptive to the appointment of both counsel to assist in certain cases and also interveners. I think we've seen a shift away from that in the Court of Appeal, which I think is concerning.
If we've got a case, it gives other lawyers a chance to be involved in maybe just doing some of the research or drafting the submissions, rather than actually fronting up to the Supreme Court, not having done much, which is really daunting. I'm a real fan of giving junior lawyers a little bit of involvement.
It's really important. We need more coming through. I think it was a really important move by the Court of Appeal and Supreme Court to introduce the practice note to give a second counsel an opportunity to be on their feet speaking. In the old days, I remember when I was at Crown Law, it was made very clear that the Court of Appeal is not a training ground. We don't want to be seeing junior lawyers appearing on matters and making submissions.
Which is the opposite now, though, because
Yeah,
now
yeah,
the
they've-
court's like, bring on the juniors.
Yeah, it's our way in which we can ensure that we have a proper retirement plan for those
Yeah,
of us
yeah,
who
yeah,
don't,
yeah, exactly.
Yeah.
Because at the moment,
Succession.
it concerns me that we're not getting lawyers wanting to do this really important work.
On one of our earlier episodes, we talked about our worst day in court and our best day in court. What's your worst day in the appeal courts? Does anything come to mind?
Yeah, actually, it's a case you might remember because it was while I was still at the Public Defence Service. I had a day out in the Court of Appeal where I was so run ragged by one particular judge that I went out of court and threw up.
We've all thrown up in court toilets.
Yeah, I remember ringing my boss and saying, and he laughed. He thought I was making light of it, but I did not really.
You're like, no, I actually did.
Yeah. Fortunately, I haven't had an experience like that since. I mean, it was a judge I respect, and it wasn't bullying. It was just, he just forensically took me apart.
Browbeating.
And then fortunately I got rebuilt by the Ministry of Justice and was good as new the next day. But it did make me briefly want to give up appeals. But best day,
Yes.
definitely Alan Hall.
Yeah.
Yeah.
And I'll tell you what, it's not something I've said publicly before because I haven't had the chance to, but the Supreme Court were incredibly impressive to give Mr. Hall justice on the day, to see the court deliver a judgment on the day. I said to the client, look, I think what we might get is a result today where reasons to follow, but to get an oral decision and one of that caliber from the Supreme Court.
Do you think they had it ready to go?
Oh, look, absolutely think that they would have had the framework, but there were things that obviously were discussed during oral submissions which were reflected in the decision. So it was one where Justice Alan France, who wrote it, would have, I'm sure, gone away and refined it. But to come back and to deliver a decision like that whilst people watched, and Mr. Hall, most importantly, and his family, an immensely moving moment. To me, that was criminal justice system working.
Yeah, how emotional was that moment? What happened?
Very emotional because, and I'm still staggered by how long it took and how many obvious signs of miscarriage of justice were missed. The thing is, if you do it well, it looks really obvious. And it looked really obvious by the point we got to the Supreme Court. But there was so much work that went into getting it to that point. And not just by me, but by Luke Elbro, who was my junior, Tim McKinnell, of course, who was the investigator. I mean, it wouldn't have been possible without him. Mike Wesley Smith, who was a journalist at that time, who really did the forensic work to get it to the point where we could take it to court. But even so, I mean, it takes such a long time to get these cases heard.
This was like an Oscars speech, wasn't it? Thanks to my
and
agent.
then thanks to this person. And
Yeah, I want to thank the Academy.
It's huge. Thank the Academy. But it was a huge moment in criminal law, I think, as well. And you were kind of a star for a while after it too. So it is good to acknowledge the team behind you.
Look, that rapidly fades. But the thing that stands out for me is that the Hall case, I think, is the case where the Supreme Court arrived. It showed that the top New Zealand court is capable of delivering justice. And I mean, I say that because we have many examples of cases where the miscarriage of justice with hindsight was really obvious, but it took the Privy Council to resolve it. And Bain and Lundy and Mr. Pora's case, for example. But I think with Peter Ellis and Alan Hall, those are two examples of cases where our Supreme Court has the pedigree and the tenacity to make a difference and to take on and recognise the miscarriages of justice.
You left Scott Watson out of that.
I was just thinking that.
Yeah, well, look, it's early days. I mean, obviously he's applied for leave because even though his case is old and in a different context, he might have had the right to apply to the Privy Council, which of course is the point. Alan Hall had that right. He could have, but with the consent of the Crown, which was properly given, he elected to go to the Supreme Court. But with Mr. Watson, of course, his is a prerogative case. So his final appeal or application to appeal lies to the Supreme Court. Time will tell, but I mean, the Court of Appeal itself recognised that it was a case that's troubled the nation for nearly 30 years. And of course, my point is that I'm not sure the judgment puts those concerns to rest. It's a matter, I think, for the top court to weigh in on.
Isn't that part of the frustration though? Because sometimes with appeals, it's like I can see it, like I can see what's happened or I can see the issue, but trying to convince the court of that is just that much more difficult.
I think with a case like Mr. Watson's, where it invokes strong emotions and where you are, of course, challenging powerful institution, police, the Crown, judges, it's difficult to be able to step back from it. And I'm too close to it as well. I mean, I have a viewpoint, but at the end of the day, my job is to be an advocate, present arguments, not personalise it. But I do think it's a case that's crying out for the Supreme Court.
I think that deserves its whole episode of its own when Watson gets to its conclusion.
Will you come back and talk to us? Or have we put
Depends
you
how it
off?
goes.
He only wants the glory cases.
I might retire, actually. It's a case which, again, it's made me think about what I do, and I'm ready for others to take over the reins with some of these things.
Why do you think junior lawyers shy away from doing appeals?
I'm not sure. Maybe it's because it's an expectation that you build up a reasonable amount of experience before you do it. And I wonder whether more junior members of our profession are into immediate gratification and want to be, and they're doing it straight away rather than necessarily watching. Well, maybe that's unkind, but I also think that it's hard. It doesn't necessarily pay as well as other areas of practice, both in criminal and, of course, wider afield. And representing defendants, it's a lonely job at the best of times. When you're taking on the Court of Appeal or the Supreme Court with their collective wisdom, it can be even lonelier. But it's also the most, I mean, I wouldn't do anything else. One, because I'm not trained to. And two, because I think it is a really rewarding area of practice.
Yeah. I think that's a bit like what the secret barrister said, wasn't it? Except he spieled on for ages about how terrible and soul destroying it is. And then at the end, he was like, but I wouldn't do anything
But
else.
I love it.
Yours was a little bit more uplifting.
You and I would say the same thing though, wouldn't we, Annabel? Be like, it is really shit most days, but I wouldn't want to do anything else.
Yeah, I wouldn't want to do it forever. I think there's a use-by date with this kind of work. You want to get out before you become too cynical. I do believe in our criminal justice system.
What else are you going to do?
Sell real estate. I don't know. Actually, sell cars. I like cars. So, yeah, I could sell a lovely motor. Yeah. But again, I'm sure I'm qualified.
I just want to ask Nick really quickly, we are going to do a separate episode just on the Tamahere case. Do you have any opinions or views on the Tamahere case?
Yes, I think one, it needed to be heard by the Supreme Court for similar reasons to Mr. Watson's case, because it raised a really important issue about the constitutional importance of juries, because the entire appeal hinged on the fact that the Crown's argument was accepted by the Court of Appeal, that the case against Mr. Tamahere, the Crown could have, should have, might have run, was so strong, even though the jury didn't hear it, that the court could apply what's called the proviso and conclude that even though there'd been a miscarriage of justice, it wasn't a substantial one, which makes a nonsense of the idea that you have a jury decide cases. So that pretty much gives you a steer of what I think. It raises pretty troubling concerns around, again, the use of jailhouse confessional evidence. The other thing, Tamahere, of course, is the leading case in the Court of Appeal on identification, which will come up in Watson if they grant leave. Again, an area that requires greater scrutiny. But look, I think listening to what the Supreme Court judges were asking, they have a different and will have a very different take on it than the Court of Appeal.
What do you think the Supreme Court's going to say?
Well, I think they'll allow the appeal. I think they see the implications. I'm sure they will see the implications
I think
of allowing the Court of Appeal's judgment to stand, where essentially it will allow the Crown to rock up on appeal with evidence it didn't use at trial.
That's right.
Evidence that it might have secured later and say, well, look, maybe the things went wrong at trial, but retrospectively we can fix those things because we've got more.
It's still okay.
And that's where the point is, it's not about saying, oh, well, that stuff doesn't matter. It does matter. But the point of it is you have a retrial at which you actually ventilate that evidence in front of the decision maker that is the jury. And that's simply it. And I think again, the Tamahiri case in the Court of Appeal demonstrates why we need a top court, why we've got one.
Yeah. All right. Nick Chisnall KC, thank you very much for coming on and spending your evening with us and your knowledge tonight.
You're welcome. Thank you.
Thanks for agreeing to come on. All the begging I had to do via text.
That's fine. I do like to feel wanted.
Yeah. Or harassed, either one or the other.
Yeah.
All
Thanks
right.
so much.
Thank
Thanks.
you,
Good to
Nick.
see you.
Good night.
I loved our chat with Nick. I like the fact that he did all the talking, but I think it's just really cool for young ones to listen to what he's got to say as well.
It's kind of a golden opportunity, really, because when you're starting out, you don't really get the opportunity to sit down with a KC and hear what he's got to say. Although, having been a young person working in Nick's office with him, he was always like that. You could always just go in and go, what is this point? And he just knows cases off the top of his head in an encyclopedic fashion that most lawyers don't have. Most lawyers do need to look things up or look them up on Chat GPT.
GPT
or LexisNexis database, actually.
Protégé, I'm basically replacing my juniors because I don't have to be like, can you tell me what this law says?
Oh yeah, but juniors still stay in the law though.
Yeah, definitely stay in the law. We need you in court, but I just harass them less with law questions. That's one thing I love about Nick, to be fair, is that you can always give him a call and go, hey, can I talk to you about this? And he never says no.
Yes, he's a KC without being a cock about it.
Absolutely.
Can I say
No
that?
no comment about other KCs. But he's so approachable. But I just like that he says it in simple ways as well that anyone can understand.
I'm bored of praising Nick now. So
we can move on now.
Good night, everyone, and thank you for listening.
Thank you to LexisNexis for sponsoring us. Don't forget to subscribe wherever you listen to your podcasts.
Thank you for listening this far. Today's episode is brought to you by LexisNexis. Your LexisNexis legal research and AI technology experience is now even more powerful with Lexis Plus AI, now with Protégé, your personalized AI assistant that will transform your legal work. Find out more today at lexisnexis.co.nz.